All right. Okay, you got it. All right. Well, welcome. Please speak in the back for those that don't have them yet. I want to welcome you all to our fourth session, the 30th season of Sundays at 2 program. I'm Ernie Monchi, and I'm on the Sundays at 2 committee. And before we introduce our speaker, Ed, I'd like to introduce the people who bring this program to you every week, every year, for 30 years in a row. So let me start with, in the back, is our chairperson, Lucy Scholler. Sheila Stepko. Pat Tracy. One boy. And me. We work year-round, not full-time, obviously, to bring this program to the community, and hopefully you enjoy it. Hopefully you'll enjoy today's program. So I also want to recognize Alice Cooper, who is our library director, who's an ex officio member of the committee. She's our logistics, technical, whatever you want to call her, but she's the jack of all trades that makes everything happen. So anyway, when you get into an evaluation, fill them out. We need your input, particularly on what you thought of today, the speaker and the subject. Do we have the right subject? And any new speakers and topics that we might want to use for the future. So one point of a change in schedule, we had to reschedule Dr. Malisi, who's talked about neuroscience, to March 22nd because of the prolonged freeze and all that ice. So we're extending our program out by another week or so to the 22nd, and that'll be our last session of the season. So please plan and join us. We also urge you to buy a library lottery ticket, $100, gets you a chance to win $5,000. Such a deal. It also supports this and other wonderful programs that our library offers for this community. We really do. There's a lot here. There's a lot for everybody. And we have a pretty good group today, so that's good too. We also welcome those who are watching today live on Facebook. You can do that if you can't make the session. And for your friends who may miss it, they can watch it later when it's posted on the library Facebook page and YouTube channel. So that's what we have going. That's our preliminary information. So let me tell you now about Ed. Today's session, constitutional issues in today's America. Our speaker today is Ed Correia. Ed is a local resident, Washington, D.C. attorney and partner in Correia and Oslo. His practice includes antitrust law, consumer protection, international trade issues, and disability law. He is also an adjunct professor at American University's Washington College of Law, where he teaches courses on evidence and constitutional interpretation. Ed served as staff director at the Federal Trade Commission and chief counsel and staff director of the Senate Antitrust Committee. He also worked in the White House under President Clinton as special counsel to the President for Civil Rights. President Clinton appointed him to the National Council on Disability. Ed was a professor of law at Northeastern University of Law in Boston from 1989 to 1997 and was selected as the law school's first urban law and public policy distinguished professor. He is a member of the board of directors of the Lawyers Committee for Civil Rights under the law. He is also an author. So he found time to do that too. I read one of his books and I really enjoyed it. He's the author of The Uncertain Believer, Reconciling God and Science. Teaching your child about God in the scientific world in 4 novels: The George Washington Constellation, Elysium, Tipping Point, and Self-Inflicted. Ed is joined today by his wife Carolyn, who is also an attorney, and she's here with us today. Not the picture. Okay, so with that, I'm going to turn it over to Ed. All you.
in particular, I'm going to talk about constitutional interpretation. Why do I want to talk about interpretation? Because justices have different views about how you interpret the Constitution. And depending on your methodology of interpretation, it takes you very different roads, and that's part of the reason we have a division on the Supreme Court today. A little bit of background. Constitutional Convention, as you may remember, was in Philadelphia in 1787. The Articles of Confederation were a failure. Didn't really have a functioning country. So the best and brightest minds, all male, all white, went to Philadelphia and started over from scratch to write a new Constitution. Now, one thing that's significant about that is, for the purposes of interpretation, is they closed the windows, they didn't take notes, there's no transcript. Madison took some notes, didn't release it until many years later. That was only a small portion of what they talked about. Now, why is that important? Because we can't really get into their minds very well. We just have a text to work with. Now, Constitution was sent to constitutional conventions around the 13 states for ratification, ratified in 1788. During that debate about ratification, it was clear that there was enormous interest in a Bill of Rights, which were not included in the original Constitution. Madison at first was skeptical about a Bill of Rights. He had worried that we have a list and we're not going to get them all, so that's going to be a mistake. But he was persuaded during those debates on ratification. So we had the first 10 amendments to the Constitution, the Bill of Rights, ratified in 1791. Why is that important for interpretation? Because years later, centuries later, when the Supreme Court is trying to figure out what the Constitution means, do they look at what it meant in 1791? Or do they look at what it means today? Or has it changed over time? Big debate on that. Constitution stressed, as you might expect, during the Civil War. But we came out of the Civil War with the country reunited, and the next new major constitutional amendments, 13th, 14th, and 15th Amendments. 13th abolished slavery. The 14th particularly important because the original Bill of Rights didn't apply to the states, only applied to the federal government. But in the 14th Amendment, those applied to the states. Two very important provisions, the Equal Protection Clause and the Due Process Clause. The new constitutional amendment says the states have to comply with equal protection and due process. That has driven so much constitutional interpretation since then. Why is interpretation so important? Well, one reason is our Constitution is a very short document. It's 7,600 words. The average the world Constitution on democracies is over 44,000 words. State constitutions are in one. Virginia's is about 22,000 words. I'm not saying this has anything to do with the quality of the government. Alabama's constitution is 369,000 words. So the point is that some constitutions can be very, very specific. What is education? What are your rights to education? What are your rights to housing and so forth? Ours is not that way. Ours is very general. So I want to talk about these different approaches to interpretation. I want to talk about some of the major issues before the court. And then we'll leave plenty of time for questions, and you can bring up anything you want to talk about. In interpreting the Constitution today, every opinion, regardless of who's writing it, will start out with the text. But the text only gets you so far. Take the Equal Protection Clause. That's clear at the time of the 14th Amendment that was primarily designed to reach equality between the recently freed slaves and everyone else. But that's not what the text says. The text says equal protection. So over the decades, that has been interpreted to apply to national origin, to apply to gender, to apply to a lot of other parts of our life, which maybe the framers of the 14th Amendment were not specifically thinking about. What does equal protection mean for the universities? Does it mean you can't have some kind of affirmative action program? Well, that's what the court said a couple of years ago in the Harvard case. You could argue, there were the votes for that, 6 votes for that, but you could argue, as the dissenters did, that the Constitution was never colorblind. There were, at the time of the 14th Amendment, programs to help the recently freed slaves. So you can debate that. But that's where the law is today. It's more or less a colorblind idea. Now, this administration has taken it somewhat further by saying we shouldn't have such a thing as DEI, diversity, equity, and inclusion, which was not ever thought to be unconstitutional. For example, have a special program to recruit people from minority neighborhoods or something like that, or a special program for scholarships for women. That was never thought to be unconstitutional. So, again, it's a question of interpretation. There's nothing in the Constitution or even Supreme Court interpretation so far that would lead you to go quite that far to prohibit DEI. The other difficult area is religion. 2 religion clauses in the First Amendment. The Establishment Clause and the Free Exercise Clause. The Establishment Clause is, the idea is you can't force religion on someone. And it's clear we can't have a national Episcopal Church as our national church, and we can't require people to go to church or contribute to the parsonage or something, all of which was done in the early days of the new colonies. 2 Virginians, Madison and Jefferson, very important in saying, no, we don't want that. We want to have some separation between government and religion. So that's one clause, the Establishment Clause. The other clause is the Free Exercise Clause. In the Free Exercise Clause, the idea is you can't discriminate against someone because of their religion. If they want to worship a certain way, if they want to believe a certain way, they basically have an absolute right to do that. They can believe whatever you want. That's the Free Exercise Clause. Now, beyond those very basic ideas, people start to differ. If you have a broad idea of the Establishment Clause, then you'd be very cautious about prayer in schools or public displays of a nativity scene. You're very cautious about that. You don't want government involved in religion. On the other hand, if you have a narrow view of the Establishment Clause, you might say, look, government can get involved in religion. You know, we have declarations, religious declarations of Thanksgiving, beginning with Abraham Lincoln. So conservatives and liberals, and I hate to use those terms because they can be very misleading, but generally, what is conservative, and I put quotes around that, has a narrow view of the Establishment Clause and a broad idea of the Free Exercise Clause, whereas progressives tend to come at it from the other direction. I'll give you some examples of cases in a little bit. Some other tough areas, presidential power. You know, what is the extent of presidential power? Here's the basic constitutional scheme. Unlike every other constitution in the world in modern society, our Constitution in Article 1, which establishes Congress, has a list of enumerated powers. Congress can do the following things. Now, that's not the way most countries have a constitution. I was in Japan a few summers ago. Their constitution doesn't start out that way. It's assumed that the government of Japan has the vast reservoir of governmental power. And unless it's limited by the equivalent of the Bill of Rights, the government of Japan can do what it wants to. Not so the United States Constitution. If Congress wants to act, it needs to be acting based on one of those enumerated powers. Now, there's a necessary and proper clause at the end that tends to broaden the scope of powers of Congress. But that's where Congress starts. What does the president get his power? He gets his power first from Article 2, which set up the presidency. If you look at Article 2, it's not very long. Some things are clearly within the president's power. The power to command the military, that's what it means to be the commander-in-chief. he or she can command the military. They can give orders to an individual officer in the field if they wanted to. It wouldn't be too efficient. But that's the power of the president. Power to pardon people who have committed a federal crime. Those are unequivocal. But when you look and see how the president acts, he doesn't base his actions primarily on Article 2. He bases on a statute that Congress passed, giving him the power to make decisions. Now, if you look at that list of enumerated powers, one of the most important ones is the Commerce Clause, power to regulate commerce among the several states, and power to regulate commerce with foreign nations. So, as a starting point, the Congress has the power to set tariffs, for example. But over the years, Congress has passed a number of statutes that give the president the power to at least regulate commerce. Doesn't, in a few cases, set tariffs, but in a very specific situation. So the case the other day had to do with the president using one of those statutes, the IEEPA, to claim the power to set tariffs because of the national emergency. What was the national emergency? Trade deficits, which we've had for decades. So the Supreme Court, even this court, said no to that by a 6-3 vote. And the big issue was looking at that statute that the president is relying upon and concluding that says nothing about tariffs. That doesn't say what an emergency is. This can't possibly be an emergency. So using a newly minted doctrine that one could argue about, but it's called the major questions doctrine, the idea is that if Congress, on such a big issue like that, if Congress doesn't speak clearly when it passes the statute, the president doesn't have the power. It's a major question. And using that analysis, that methodology, they struck down the tariffs. Now, there are other statutes. My own view is the other statutes are even sort of a harder sell with the Supreme Court. You have to push that language pretty far. However, the president has said he wants to continue using another approach. Now, let's go back to interpretation. Here's the basic split. This is an oversimplification, but it gives you the idea. One school of thought is that the Constitution means what it meant at the time the language was adopted. If it's in the Bill of Rights, that's 1791. If you're looking at the text of the 14th Amendment, that's in 1868. What did the Constitution mean then? The other view is that, no, you've got to interpret the Constitution based on changed values and conditions that have evolved since that language was adopted. Now, so I want to talk about 3 different approaches to interpretation. Again, a bit of an oversimplification, but I think it'll give you what the big split is. One idea is originalism. Yeah. The basic idea of originalism is the task of the Supreme Court is to apply the Constitution as understood at the time the language was adopted. The second approach I'm going to call pragmatism, even though that's sort of a loose label. It encompasses a number of approaches, including what's sometimes called a living constitution, where the meaning will change over time. And a third approach I'm going to call structuralism, where the approach is to say, what does this mean for the way the branches relate to each other, and the structure of the government in the original Constitution? Now, in real life, you might see more than one of these modes in the same opinion, and justices might have a slightly different approach to that, but let's say those are the 3 big approaches. Let's go back to originalism. Seems pretty logical, doesn't it, to apply the Constitution as intended at the time? Well, that has a certain power to it, of persuasiveness. And there are some really advantages in that theory. The biggest advantage is that the Constitution has a fixed meaning, so future judges can't just make it up based on their own values. That's the great attraction. We had an agreement at the time this language was adopted. We all joined hands in the country, procedurally at least, to say this is the Constitution, this is what it means. And if you want to change it, there's a provision in the Constitution to amend it. That's the great power and attraction of originalism. Some of the weaknesses have to do with how you do it. When the first proponents of originalism basically tried to get into the head of the framers. You see the problem with doing that. No notes if you look at the Constitutional Convention. How do you get in the heads of the framers? So that methodology sort of changed over time to say, we can't really get in the heads of the framers. Let's try to see what the public meaning of that language was at the time. How do we determine what the public meaning is? Well, you could look at law review articles or something like that. That doesn't seem too persuasive. But the basic approach is, let's look at history and tradition. How was that language of due process applied at the time it was adopted in the 14th Amendment? For example, what did states do about abortion at that time? Did they prohibit abortion? If abortion was widely prohibited at the time the due process clause was adopted, then how could you, 100 years later, say there's a right to an abortion? You would apply history and tradition that way. A little bit of a problem with that, and when you try to figure out the laws to look at, there might be thousands, might be hundreds or thousands, depending on if you look at European law or you look at common law in England. So you risk cherry-picking your sources. You pick the historical examples that support your outcome, and you minimize the historical sources that support the outcome you don't like. So what starts out as a claim of objectivity really turns out to be a very subjective approach. That, the critics might say that's a weakness. Let's take Brown v. Board of Education and see how originalism worked. Brown was in 1954. At the time, schools in the South particularly, but some in the North, public schools were segregated. And the court had applied since Plessy v. Ferguson in the 1890s, this idea of separate but equal is constitutional. Now, the court avoided the problem for a long time by saying, well, those two law schools, the black law school and the white law school, they're really not equal. So we can strike it down because they're not equal. But finally, the court realized we're going to have to face this squarely and say, even if the facilities are assumed to be equal, should the state still allow schools segregated expressly on race? And by a unanimous vote, nothing that the Supreme Court said, separate was inherently unequal. Now, you can try to justify that decision as an originalist decision. Very hard to do. Because when the 14th Amendment was adopted, the schools in the District of Columbia were segregated. There's not a word on the floor of the Congress about the Equal Protection Clause, getting rid of segregated schools. So it's very difficult to argue as a historical matter that the people who adopted the 14th Amendment Equal Protection Clause thought they were striking down segregated schools. They weren't. Even Justice Scalia, who was probably one of the biggest proponents of originalism, said, in some sense, he says, I'm a weak-kneed originalist. I'm all the way. Because I can't go all the way to saying Brown was wrong. Because it can't be justified as a historical matter. So how did the court decide Brown? If you look at that opinion, Earl Warren, the Chief Justice, said, well, things have changed. Things have changed since the 14th Amendment was adopted. So now let's talk about the problems with pragmatism. The great advantage of pragmatism, which is what I'm calling this alternative approach, is that you can take account of change conditions. You can take account of change values in society. What's the weakness? The weakness is that it opens the door to judges just putting their own values in the Constitution. and just saying the Constitution is what I like about it. I want our country to be this way, very subjective. And that's the criticism of pragmatism, that it opens the door to that. Let's take another example. Gun control. When you read the Second Amendment, if you don't have a pocket constitution, a well-regulated militia being necessary to the security of the free state, the right of the people to keep and bear arms shall not be infringed. Well, you listen to that language, and it does seem like it has something to do with militias. You know, it starts out that way. In fact, in Miller, the Supreme Court said in 1939, it was about militias. In 2008, opinion by Scalia looked at that language. There's a long discussion about parsing the comments and the structure of the law. So, well, that first clause is really not binding. It's really the second clause that's binding. It's the right to keep and bear arms. Therefore, it applies to not militias. It applies to private ownership of guns too. Striking down in the District of Columbia handgun law, foreign handguns in their privacy of their own home. And Scalia said we are basing that on history and tradition. Then scroll forward a little bit, 2022 case called Bruin, which had to do with the New York City's licensing law. And there's 6-3, again, to strike that law down. But the 3 votes, you look at the dissent by Justice Breyer, not on the court anymore. The first 5 or 6 pages of that dissent are, we have an enormous number of child deaths, an enormous number of suicides, going over all the consequences of having, in his view, so many guns, particularly in big urban areas. Justice Alito, in the majority, said, I don't get what Justice Breyer is talking about. That's completely irrelevant. All those statistics about guns, what does that have to do with interpreting what this amendment meant when it was adopted? The other interesting thing about that decision is, to go back to Scalia, remember he said, I've studied all these historical sources on what does it mean the right to keep and bear arms. It means private ownership as well as public ownership, but certainly private ownership. By the time Bruin was decided, these historians, a big group of historians, had done a study of 160,000 historical references to the right to keep and bear arms. Now this is a real historical study, and found the overwhelming use was military use. So one problem is, it's just the difficulty in doing an historical approach. It might give you some sense of objectivity, but then you have to worry, well, are you just picking your sources out? Another example of a difficult area is privacy. Yeah. The word privacy is not in the Constitution. It's not in the Bill of Rights. How do you even come up with a theory of privacy in the first place? Well, if you look at the early Supreme Court decisions, they had to do with teaching a certain language in schools, and then you let the community decide you could teach German or how the Jehovah's Witnesses family allowing their kids to go give out Jehovah's Witnesses literature. Doesn't seem to have much to do with abortion, but those were the early privacy cases. They evolved to Skinner, which is a sterilization case, and Loving, by the way, Virginia case, about a law, Virginia law banning black people from marrying white people, striking that down on equal protection grounds. But right at the end of that opinion, the court said, you know, there's a due process basis for this too, because it has to do with the fundamental interest of how you regulate your own life. That then became another step toward a privacy idea. Then we have the Griswold decision in the 1960s, which had to do with use of contraceptives by married couples. Connecticut, Florida. Connecticut wouldn't do that today, but it did. And the court said, you know, that's got to be in violation of some fundamental interest. But where do you come up with it? Well, Justice Douglas wrote the opinion for the court, where he had, it was only his vote for it. A number is some of the Bill of Rights language. Three justices relied on the Ninth Amendment, which is unenumerated rights that are not stated in the Constitution. Others relied on the Due Process Clause. But that took us to Griswold, and it's not that big a leap from going Griswold to Dobbs, Griswold to Roe. And we had 7 votes to say there's a constitutional right to an abortion. That's over now by virtue of Dobbs, where you had 6 votes saying no more privacy cases. That was wrongly decided. Where you came up with that theory was wrong in the first place. And Justice Thomas said, yeah, we should go back and revisit Griswold. We should go back and revisit Obergefell, which is gay marriage. We should go back and revisit Lawrence, which had to do with privacy of gay sexual activities. Whether they'll do that, I don't know. But there's one justice saying he would like to do that. Let me say a quick word about structuralism. The idea of structuralism is you look and see how the branches are supposed to interact. As you all know, you learned this in junior high. The Constitution, a nascent document, following the theories of John Locke and Montesquieu at the time, said there should be some checks and balances that each branch has against the other. They were very afraid of having a monarch return. They just fought George III. They didn't want to go back there. And so how did they prevent one of those branches from dominating the others? Checks and balances. You have to get a law passed. You have to pass the House. You have to pass the Senate. It has to be signed by the President. If the President doesn't sign it, you can override the President's veto with a 2/3 vote. Lots of procedural mechanisms in the Constitution to prevent one branch from being dominant. My example of structuralism is the immunity decision that was a couple of terms ago. And the idea was, is a president, after he's left office, can he be prosecuted for conduct while he was in office? And that led to the immunity decision. And it's a complicated opinion, but the underlying idea was, the opinion really just announces a very sweeping immunity. Not complete, but a very sweeping immunity. The underlying theory is a structuralist idea that for the president to be aggressive and be willing to exercise his office and be a powerful executive, not be chilled, he can't be subject to criminal prosecution after he's left office. That was the theory. You might question that from a historical basis because there was never an immunity before now. And you think Lincoln and FDR and Harry Truman were chilled in their aggressive use of their office because of lack of immunity? Kind of hard to argue that. But that's an example of a structuralist opinion. All right. Let me turn to just a few issues that I want to put out for questions. What do you have up there? Well, the thing we just had was the tariff decision. And the tariff decision is a statutory interpretation decision. Technically, it's not a constitutional interpretation. But the underlying it is the notion that Congress is the one that has the power to regulate commerce with foreign nations. Congress is the one that has the power to set tariffs. So if it's going to authorize the president to go out and do that on his own, it's got to speak very clearly in the statute, which it did not. That was the result of that tariff decision. Got some other cases up there now. We've got some religion cases. One has to do with a ban on conversion therapy, a Colorado statute that says we don't want our licensed psychologists or psychiatrists in the state trying to convert people from being gay to straight. But if you look and see their approach, it was mainly kind of a Christian approach, you know. And so by saying on the court, and I think this is the way this is going to come out, by saying youth therapists cannot talk about religion in trying to convert people, That's a restriction on your religious rights, a restriction on your speech rights. Another case up there dealing with a charter school in Oklahoma, that if the Supreme Court upholds it, it will really allow public funding of what is essentially a school that's teaching religious doctrine. Now, if it does that, that will be quite a change from the traditional approach to the Establishment Clause. Remember, I said the Establishment Clause is the idea government can't promote religion or push religion on it. The framers, Jefferson and Madison among them, very nervous about this. But if you come all the way to 2026 and say, no, we don't really have a problem with Oklahoma having a charter school that promotes religion, then you really changed your approach to the Establishment Clause. Other major cases dealing with transgender women in sports, and two states, West Virginia and Idaho, banned trans boys, born as biological boys, but a trans girl participating on a women's sports team. We'll see how they deal with that. All right, well, let me just say a couple things that I want to open that. If you were really cynical, which I'm not, you might say these justices are just making this stuff up, the outcome they wanted. I don't really think that's the right intellectual approach. They have to write long, complicated, scholarly opinions that are going to be judged by the test of history. And therefore, I think you have to just look and see what they say to see whether it holds up intellectually. Again, these are not easy questions. The great strength of originalism is it says we have a meaning at what time. That's the objective thing. That's what we've agreed to. Let's go back and use that as our touchstone. On the other hand, you have progressives saying things change over time. In 1868, you weren't worried about segregated schools. In 1954, we were worried about segregated schools. You've got to change the Constitution over time to deal with different conditions, different values. And the only way to do that is you've got to trust the reasoned judgment of Supreme Court justices. So you don't have to decide where you come out on that. All right, we'll stop right there. See what questions you have.
Questions?
I'll cover this side of the room, Ernie, and you cover up there, and I'll kind of
What would be the argument,
just hold it close to you.
what would be the argument to kill birthright citizenship? Where do you think that's going, and how would that be argued?
If you see the way the 14th Amendment starts out, you would think it's pretty cut and dry. It basically, in paraphrasing, everybody born in the United States is a citizen, and no being independent. However, the framers added this clause, subject to the jurisdiction thereof. In other words, you're born here and you're subject to the jurisdiction of the United States. Now, 1898, first time the Supreme Court really dealt with this directly, it said, what does that mean? Well, if you're born here to a soldier in an invading army, or you're born here to a foreign monarch who's just visiting here, you're not a citizen of the United States. Because under the circumstances, you aren't subject to the jurisdiction of the United States. So you can kind of see how you could carve out very special exceptions there. The question is whether you can take that language subject to the jurisdiction thereof and broaden it to mean you came here illegally. I think that's a stretch, but that's the argument to support it.
Questions?
When the Supreme Court overrules a previous decision, aren't they by definition opening themselves up to being overturned themselves?
Well, in a sense, unless you were to take, and by the way, no justice, as far as I know, has ever taken the position that once a Supreme Court decision comes down, it's locked forever. They always, the debate is, how much weight do we put on stare decisis? a whole lot of weight or not so much weight or whatever. So the three worst decisions historically in history have been Dred Scott, which was before the Civil War, that said not only can this person not be freed and meted up to Illinois, but it's a violation of due process to control people's right to own slaves. And it was a completely disastrous opinion, which led to the Civil War. Well, certainly prompted it. Everybody would say Dred Scott. Now, the 14th Amendment overturned it. But then you get to Plessy in the 1890s, and Plessy, also viewed as one of the worst decisions, said separate but equal is constitutional. Now, that's what this scroll forward to 1954. That's what the Supreme Court had to deal with. And so you've got to overrule Plessy. You've got to say Plessy was wrongly decided to come out with Brown, which is what they did. So you have to leave room for a decision like that. Now, compare that to Roe v. Wade and Dobbs. Because what the dissenters said in Dobbs was, wait a minute, Roe v. Wade has been the law of the land for 50 years. You can't overturn it. And the other side said, no, this is like Plessy. This was wrong when it was decided. It takes no interest in the welfare of the fetus. It was wrong, and we're going to overturn it.
Can you define conservative and liberal?
I think that's a very fair question. That's the reason I use the real word progressive rather than liberal. But yeah, I would say those values could be, those labels could be very misleading. Conservative in this context tends to be, originalism is more favored by conservatives, and more of a values consequences approach to interpretation is favored by progressives. But again, can be very misleading. If you were you could be a very conservative, staunch Republican, and be in total agreement with this tariff decision that just came down. Because you can say, that's not what the framers meant. They didn't mean to have this sweeping president exercised without direction from Congress. That's really a conservative view of the way this could be misleading.
But I'm not going to do a good thing. Hey, thanks a lot. I'm going to make a pitch for the library. What I want to do here. Listen, I have this book here which is called How to Interpret the Constitution. It would be free downstairs for $2. Today, I'm giving it away as a gift along with a $100 check to the library. First one gets over here. For the cynics in the audience, I am definitely one of them. Let me back up a tiny bit. Dad's a lawyer, two brothers are lawyers, and I have a lot of trouble with lawyers. But for the cynics, we the people is where that starts. If we the people is determined by 9 gentlemen or ladies, we don't have any real foundation. We have something that a bunch of people decided that they sort of thought was a good idea, and then other people don't think it's such a good idea. We have things that I was an English teacher. I can't imagine the Second Amendment meaning anything but in order to do X, Y will happen. That's a coordinate clause and defines the main clause. It's impossible to interpret that any way at all. So I'm looking at this as a cynic. I don't know what would be better. I think that this country is determined for so many years we have to follow the Constitution. We've been hearing for the last year or two, oh, the Constitution isn't quite right here. Companies are individuals, but you can't sue a company and put a company in jail. It's completely illogical. So I'm questioning, with all of our basis on we the people, it's a fallacy of today's world, and I don't know what to do about it, but I'd like your opinion.
Yeah, sure. Let me make a pitch for the importance of the Constitution, even though it's got the weaknesses that you mentioned. And the pitch would be, what would you do without it? Then you wouldn't have any common guidance. At least we got a common guidance and common text. We could fight about the meaning of it. But if we didn't have a common text to start out with, then it would just be subject to the will of Congress, assuming Congress asserts its power at all. Or it would be subject to the will of the president, unrestrained by Congress, without having to rely on the text of the Constitution at all. So it's a system, you know, if you look back at the framers, I mean, these folks, this was a new experiment. There weren't models to go on. They had just come from England for the most part, and a monarchy, and they were making this up. So it's served us pretty well. Stressed at times, Civil War particularly. Every war is a stress on the Constitution. So I'm hoping we can hold it together. I get the cynical argument. I'm a little cynical myself, but I think it's better than the alternative.
I'll throw in just one idea about the Second Amendment. I've been reading before that, after it. No question in my mind, they had a completely different theory of commerce back in the late 18th century.
Yeah. Well, yeah, the Second Amendment can be a very provocative topic, so I don't want to get too far afield on it. I do think if it's just a methodological question, it's kind of hard to look at the amendment and say it had nothing to do with militias. But anyway, we're where we are. The good news is that the court has been able to look at some, like Rahimi had to do with being able to restrict guns from getting in the hands of people who were subject to some domestic violence or something like that. And the court was able to say, well, that seemed to be enough, something like that, back in 1868. So it's not a disaster. I do think that in places like New York, you don't have the problem down there so much. When you go to New York, or you go to DC, or you go to Philadelphia, you're trying to do something with your environment that has thousands and thousands of guns circulating. And the fact you can't really do much about it could be a problem.
I hear it. There's been some recent proposals for changing the Supreme Court term limits and the constitution of the court, and presidents should be able to appoint people to the court. What do you think about that, both in terms of the theories and the practicalities of making a change?
Well, I was on it. I don't know if you remember this, but Biden appointed a Judiciary Reform Commission or something like that. And I was not on the commission, but I was on the Lawyers Committee, had a special committee to make recommendations. And we did recommend a limitation of terms and an age limit. And so I voted for that. I thought it was a good idea. Here's the reason it's not going to happen. At any given time, keep in mind the way Congress works, as those of you know. You got to get a majority vote in the House, and then you got to overcome a filibuster on the Senate. And so that's unless you've really got a lot of one party in the Senate, that's already a problem. The other problem is, at any given time, putting an age limit on hurts one side or the other. So the side that's hurt is not going to go along with it. And then if you wait a little while and the other side takes over, they may be hurt by it, and the other side is going to get it right. And the same thing is true on the size of the court. The size of the court is not specified in the Constitution. You can have a 15-member court, you can have a 3-member court. But the only time in history that a president really seriously considered it was FDR to pack the court. You know, it just politically, as much political power as FDR said, that kind of was fizzled out. Now, it might have convinced some justices that they better change their interpretation methodology, which they did. But I just don't think it's a practical matter we're going to be able to change the size of the court, or we're going to be able to put a term limit on, even though in theory it might be inside the
Constitution, and is it still necessary? As a constitutional lawyer, what amendments would you like to see happen, if any?
Well, I'm going to get Dude out of the room. Let's do a little review. Here's the way I would think it. To amend the Constitution, you have to have a 2/3 vote in the Senate, a 2/3 vote in the House, then have it ratified by 3/4 of the states. Now, can you imagine in our society anything you could get that much agreement on? Probably not. It's not of any significance. I think the constitutional amendments, the Bill of Rights, I would have liked the framers to be a little more specific, but they are a beautiful set of ideas. So I don't really think we need new constitutional language. Well, I'll stop right there. I was going to talk about the Bill of Rights Amendment, but I think I'll say no.
What do you think the chance of Citizens United in reverse?
0. Really, I mean, as a practical matter, to reverse Citizens United, you have to get a fundamental new membership on the Supreme Court. And that's not going to happen. I mean, we have the people in that court, if you look at their ages, they're going to be there for a long time. So, and you certainly can't get a constitutional amendment. So, some things I think we're just going to have to accept as part of the constitutional scheme, and not spend a lot of time and effort trying to change it, because I don't think it can be changed.
The Supreme Court is being very political. How do you see it?
Well, it depends on what you mean by political. I mean, do they just do the bidding of the president all the time? No. I don't think they do. They just decided to knock out his major economic policy by 6-3 vote. So if your hypothesis is they're going to support the president all the way, they didn't do it here. They had 5 votes to say he couldn't send troops into Illinois. If the governor doesn't want him there, unless it's something the military has to do, and even if it's the military, they're limited by the Posse Comitatus Act, they can't do domestic law enforcement. So that was a loss for the president. We'll see what happens. Are they ideologically consistent or with the president? And most conservatives, yes, I think that's true. But I don't think they're as political in the sense they're doing the bidding of the president. All the time.
Let's go back to the tariff question for a minute that you spoke about earlier, Ed, when the Supreme Court just struck down by a 6-3 margin the current tariffs. And then you mentioned at some point, I didn't quite get the clarity of it, was that there's 2 other ways the president can reimpose these tariffs without Congress. Could you explain the potential for that being done and it being constitutional or unconstitutional?
Well, I'm only familiar, and I'm not that familiar, but a little bit familiar with the other 2. One has to do with when you're having a trade dispute and one side is accused of dumping or something like that. The president can impose temporary duties. I think that lasts for 150 days. This being got to be in the context of his trade case. The other has to do with basically equivalent to the Insurrection Act or something. Failure to, you need to regulate tariffs, or you need to regulate tariffs, and you need to regulate your economy, and by implication tariffs in order to control or break down the laws. It's a stretch. Even if you were willing to say it includes regulation, Supreme Court, this last opinion said just because you regulate you can't impose tariffs. I think there are going to be stretches, but we'll see. Now, as a practical matter, the president can go ahead, and district court can enjoin it, the Court of Appeals can enjoin it, but if the Supreme Court says, well, we need to look at this, and what the Supreme Court has frequently done is say, we're going to stay the opinion, meaning this order that the district court entered to say you can't do it, we're going to put that on hold so you continue to impose tariffs. That may be where we end up. That means another 2 years we'll have tariffs before we get to the Supreme Court. If they do that, it could be. I don't know if they'll do that or not, but they might. Anything else?
Any other questions from the group? Go ahead, Lucia.
One last question.
Okay.
I know what your answer is, but I found your answer illuminating. And that is, what happens if the Supreme Court issues a ruling and then a president doesn't abide by a statement?
Well, that's a tough one. I think everybody who follows this is probably nervous about this. Well, let's go back in time. You remember Richard Nixon and Nixon to the United States when he was ordered to turn over the Watergate tapes. And at that time, he was asserting that he had the right to define executive privilege and so forth. And the Supreme Court said, no, we told you it's privilege. That's not privilege, you got to turn it over. And living in Washington at the time. And everybody held their breath and thought, boy, this could be a constitutional crisis. Now, the Supreme Court was unanimous. They made it a point to be unanimous and make sure that order had the best chance of adhering. He did comply with it. If he hadn't complied with it, he would have been impeached and probably convicted. So the handwriting was sort of on the wall. But we went up to the brink of the constitutional crisis and then stepped back. What is encouraging to me recently is the administration, when the Supreme Court said you can't send those troops to Illinois, they withdrew the troops. Now, if you were going to confront that idea that I don't have to comply with the Supreme Court order, that might have been the time to do it. Doesn't it on popular grounds, immigration and so forth. But I take some comfort by the fact the administration pulled back. So I'm just hoping we don't face it.
Following up on that, what do you do about the illegals in the group who are sent down to another country, ordered to be back by a judge, and the president completely ignores that, and the judge has said, many, you know the judge, I don't, who said, you have broken our rule X number of times, we are going to hold you in contempt. Holding the president in contempt, he can do no wrong legally, so how do you hold him in contempt, and what does that do to the lower one? Same with the Supreme Court election.
Yeah. Well, as people have said, the Supreme Court didn't have any troops. They don't even have a marshal service. They got a little tiny security operation in their building. They rely on voluntary compliance with the norm. And that becomes, therefore, more of a political question than anything else. I mean, we just hope we've held together for all these years. Hope we can still hold together.
Okay, that's it. A few minutes afterwards for any discussion or questions. We have, leave your surveys on the table. We have cookies, coffee on side for everyone, free of charge. And next week, on Friday, Sunday, March 8th, we will have Dr. Alina Baker-Rogers, Murray Hanson, 1776, a block of Rectum. Please join us for that program. And the free book will be downstairs, and you got it.
And don't forget,